In May of 2019, one of Aretha Franklin's nieces was going through the house in suburban Detroit and found a spiral notebook shoved down between two couch cushions. 4 handwritten pages. There was a smiley face drawn next to the signature. It took a jury in Pontiac, Michigan, less than an hour, 4 years later, to decide that notebook was her last will and testament. And by then, 3 of her 4 sons had spent those 4 years suing each other. The story usually gets told as a cautionary tale about not writing things down. That is not what happened. She wrote plenty down. What she got wrong was what went into the document and what should have stayed out of it. And you can get that wrong with a beautifully typed, properly witnessed, lawyer-drafted will sitting in a fireproof box right now. 56% of American adults have no estate planning documents at all. Will ownership actually fell in a single year from 31% to 26%. This is not a video about the people who did nothing. It is about the ones who did the responsible thing and then loaded that document with 12 categories of things it was never built to carry. Before the list, understand what a will is, because almost nobody does. It is a set of instructions addressed to a probate judge, which means it is your ticket into that courtroom, not your way around it. Nationally, that process averages about 20 months. It consumes somewhere between 3 and 7% of the gross value of the estate before your family sees a dollar. And once it is filed, it becomes a public record that anyone can walk in and read, including a stranger who is specifically looking for families with money and no one paying attention. Hold on to that last part. Half of this list comes out of it. Number 1, retirement accounts, life insurance, and anything else with a beneficiary designation on it. William Kennedy worked for DuPont. In 1974, he named his wife Liv as the sole beneficiary of his savings and investment plan and named no backup. 20 years later, they divorced, and the decree stripped her of any claim to his retirement money. He just never went back and changed the form. When he died, roughly $400,000 went to his ex-wife. His daughter, Kari, as executrix, fought it all the way to the Supreme Court. And in January of 2009, a unanimous court sided with the plan. A divorce decree lost to a piece of paper he filled out in the 70s. And fixing it would have taken him 15 minutes and cost nothing. The form beats the will every time. Your 401k, your IRA, your life insurance, your payable on death bank account, your transfer on death brokerage account. None of those read your will. They read their own records. Name Sarah on the account and Michael in the will, and you have not built yourself a backup. You have built a contradiction, and a contradiction is exactly what a disappointed heir's attorney is hunting for. Number 2, jointly owned property with rights of survivorship. That house, that account, that title transfers to the surviving owner the instant you die. It is gone before anyone finds the will. Naming it in the document does not change ownership. It just creates confusion and gives somebody a reason to argue. Number 3 tends to catch people who thought they were being thorough, which is the frustrating part. Anything you already funded into your living trust. If the deed says the trust owns it, the trust owns it. Listing it in your will is a claim on property you no longer hold, and courts do not honor claims like that. Number 4, passwords, account numbers, social security numbers, and cryptocurrency keys. Remember, the will gets filed with the court and becomes a public document. Clients hear this from their attorney and are still shocked when they think it through. Meanwhile, an estimated $140 billion in Bitcoin is already permanently lost, sitting in wallets nobody can open, because the owners died and the keys died with them. More than 40 states have adopted the revised Uniform Fiduciary Access to Digital Assets Act. Put the legal authority in your documents. Put the credentials in a vault, a safe, or an encrypted password manager, never in the will. Number 5, funeral and burial instructions. This one is heartbreaking, mostly because of how ordinary it is. The will frequently is not located, opened, and read until days or weeks after the service is over. You wanted cremation. They chose burial. You wanted a specific song in a specific place, and nobody knew because you put your last wishes inside a document designed to be read after the last wishes stop mattering. So tell your family out loud while you can. Write it in a separate letter. Give copies to whoever is going to be standing in a room at 7 in the morning making these calls without you. Number 6, your pets and the money to care for them. Under the law, animals are property, and property cannot own property. You cannot leave your dog anything. You also cannot legally force whoever takes your dog to spend a dime on the animal, which is the part that tends to land badly. Leona Helmsley left $12 million for a Maltese named Trouble. Her heirs sued, and the court cut it to $2 million and redirected the rest. All 50 states and the District of Columbia now authorize pet trusts, Minnesota being the last to sign one into law. A pet trust separates the money from the caregiver and gives somebody the legal standing to enforce how it actually gets spent. Number 7, and if you have young children, this is the one to sit up for: an outright inheritance to a minor. Parents assume the guardian they name to raise their child will also handle that child's money. Those are 2 separate roles under the law. law, a minor cannot legally hold property, so a court appoints a property guardian, often requires a bond, and then supervises every dollar. Braces require a petition. Tuition requires a petition. Each one means fees and waiting. And on the child's 18th birthday, whatever survived that process gets handed over in one lump sum, ready or not. Number 8, a straight gift to someone with special needs. This is generosity that lands like a punch, because if that person receives means-tested benefits like Medicaid or supplemental security income, an inheritance dropped in their lap can disqualify them. You meant to make their life easier, and you interrupted their health care. The tool is a supplemental needs trust, which supplements what the benefits already cover instead of replacing them. Number 9, conditional gifts. If she graduates, if he stays married, if she stays sober. Conditions invite challenges, and they can keep the whole estate from settling. Ask who enforces it. A probate judge with a docket full of cases has no interest in verifying whether your grandson finished his degree. Real incentives belong in a trust, where a named trustee has the standing to evaluate them year after year. Number 10, fixed dollar amounts to individuals. Say your will leaves $100,000 to your friend Robert, and everything remaining split equally among your 3 children. Then a long illness drains the accounts, and you die with $50,000. Robert's gift comes first. Your children get nothing. Percentages flex with whatever is actually there, which is why almost every drafted plan uses them. Number 11, your reasons for cutting someone out. The impulse is completely human, and I understand it. You want the record to show why. But that paragraph goes into a public court file. It gets read aloud in front of the person it describes, and it hands them a motive and an argument in the same breath. One neutral line does everything you need. For reasons best known to me, I make no provision for this person. There is also a limit here that surprises people. In most states, you cannot fully disinherit a spouse at all. The elective share lets them claim a statutory portion anyway, commonly a third to a half, whatever your will says. Number 12, your business and your firearms. Probate freezes things, and a business cannot sit frozen for 20 months without bleeding customers and value. Business interests belong in a trust or a buy-sell agreement, where the transition happens the same week and stays private. Firearms are their own animal. They sit under layers of state and federal regulation, and handing one through a will to somebody legally barred from owning it can turn your executor into a criminal defendant. That is what a dedicated gun trust exists to prevent. So what is a will actually good at? It nominates the guardian who will raise your minor children, and that alone makes it essential. It names your executor. It catches the strays, the assets you forgot to retitle, through the residuary clause. And in a properly built plan, it does one more thing. It pours whatever is left over into the trust that does the real work. Many states also let you attach a personal property memorandum, a signed list of who gets the ring, the tools, the china, the guitar, whatever it is, and you can rewrite it any afternoon without touching the will itself. All 12 of these come back to the same thing. A will is a narrow document. It speaks to one audience, a judge in one setting, a public courtroom, about the assets nobody else already has a prior claim on. Push anything else into it, and you are using it for a job it does badly. And the cost of that never lands on you. It lands on the family standing in a hallway outside a courtroom, finding out things about each other they cannot unfind. Go back to that couch in Detroit. Aretha Franklin had money, family, and every resource on earth available to her. What she did not have was the right document doing the right job. So her sons learned what she wanted from a notebook a jury had to interpret for them. Your family will learn what you wanted from whatever you leave behind. They will learn it on the worst day of their lives. So pull out your will this week and read it the way a stranger in a courthouse would read it. Then take out the 12 things that were never supposed to be in there. A will tells the world who gets your things. What your family actually needs is a plan that tells them who you were. If you like this video, don't forget to subscribe and click the next video on your screen to learn how to make a valid will in 8 minutes.